All rise.
Kosovo Specialist Chambers is now in session.
Good morning, everyone. Welcome in and out the courtroom. Madam Court Officer, can you please call the case?
Good morning, Your Honor. This is KC BC 2020-04, the Specialist Prosecutor versus Pjetër Shala.
Thank you, Madam Court Officer. Now I would kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Mr. Prosecutor.
Thank you, Your Honor, and good morning to all present. Appearing today for the prosecution are Legal Officer Bernhard Kuchnik, Case Managers Angel Langenberg, and Daniel Mezai, and I'm Prosecutor Sean O'Dowd. Your Honor, I'd like to take a brief moment to acknowledge that this is the last court appearance for Ms. Langenberg, who will be moving on. We thank her for her work, and I want to inform the court that Mr. Mezai will be taking over for her responsibilities in this case.
Thank you, Mr. Prosecutor, and all the best for your future challenges. Now let me turn to the defense, please, Mr. Gillissen. Microphone, please.
I think it was. Yes, I think so. It's better. Thank you. So I am proud to present to you Mr. Awini, my co-counsel, and a new person in our team, an intern, Miss Manon Moulare. She is a French-spoken person from Marseille with a son in the voice, if you understand exactly what I want to mean. So we have Mr. Shala with us by video link, and we are complete, Mr. President. Thank you.
Thank you very much, Mr. Gillissen. Mr. Roche for the registry, please.
Good morning, Your Honor. I'm Ralph Roach from Judicial Services Division in the Registry. Thank you.
Thank you, Mr. Roche. I note that Mr. Shala has waived his right to attend in person the status conference, and that he attend this hearing via video conference. And for the record, I am Nicholas Guillou, pretrial judge for this case. On 14 September, I scheduled the third status conference in this case. My goal today, as usual, is to review the status of the case and to organize the exchanges between the parties to ensure an expeditious preparation for trial. In particular, I wish to discuss disclosure of evidentiary material, translations, the status of the specialist prosecutor's investigations and the date of its pretrial brief, the status of the defense investigations, the points of agreement on matters of law and facts, the detention regime, and finally, any other issues the parties may wish to raise. I thank the SPO and the defense for their submissions ahead of this status conference, and as usual, I invite all the parties to present their views in a concise fashion for each item on the agenda that I will address individually. Let me start with the first topic on our agenda today, which is disclosure. I will give the floor to the parties on the disclosure of each category of material separately, starting with the Rule 1021B material, which is the evidentiary material that the SPO intends to use at trial, followed by the Rule 1023 material, which is the material relevant to the case as listed by the SPO. Then the Rule 103 material, which is exculpatory material, and finally the Rule 107 material, which is protected material for which consent of the provider is requested. Let me start our agenda today with the disclosure of evidentiary material the SPO intends to present at trial. The SPO indicated in its written submissions that it completed its Rule 1021B disclosure, except the materials for which protective measures requests have recently been ruled upon in case 6 that are now being processed for disclosure, and certain other such requests that are pending in case 6, and remaining Albanian translations. And I note regarding these translations that I think you have disclosed last night or this morning a further batch of translation in Albanian. The SPO also requests authorization to disclose 2 forthcoming expert reports relating to forensic matters, pursuant to Rule 121B. The SPO indicated that it anticipates being in a position to disclose these reports, which have not yet been received, by 8 October 2021. So I will invite the SPO to indicate when the disclosure of the materials for which protective measures requests have recently been ruled upon in case 6 will be completed, unless it has already been completed. Then, if the materials for which protective measures requests are still pending in case 6 fall under the scope of the currently pending requests for protective measures in case 6. Then, if the translations of the Rule 121B material will be completed by 25 September, as indicated in your written submissions. And finally, what are the reasons for the delay in finalizing and disclosing the expert reports, given that the indictment in this case has been filed more than 18 months ago? Mr. Prosecutor, you have the floor. Microphone, please.
Thank you, Your Honor. I'll take each of those points in turn. First, with respect to materials that are subject to protective measures, all materials, all items that are subject to protective measures that can be disclosed have now been disclosed. The remaining items are the subject of a pending motion in another matter. Second, with respect to the remaining Albanian translations, Your Honor correctly notes that we produced additional translations yesterday, and that is the conclusion of the Albanian translations of the prior witness statements under 102(1)(b). Finally, with respect to the expert reports, the SBO has previously identified to the court the fact that there were a limited number of investigative steps outstanding. These investigative steps included following up on certain forensic reports that have already been disclosed to the defense. We had hoped to complete that process by the 30th of July, and we were in fact able to make contact with the relevant individuals and task them by the 30th of July, but we did not receive the reports at that time. So we seek leave of the court to produce additional 102B materials on or before 8th of October 2021.
Did you get the confirmation that the reports would be finalized by that date, or is it a target date for you?
My understanding is that they will be received by that date. My understanding is that one of them may have already been received and is being processed into evidence, and that we're waiting for the second report.
Thank you, Mr. Prosecutor. Let me now turn to the defense. On the Rule 102(1)(b in general, Mr. Gillissen.
Yes, Mr. President, thank you very much, Your Honor. So I can confirm the presentation just made by the prosecutor's office. I think I can add that we had an agreement on a common table identifying the document which still seemed to be a problem as those missing Albanian translation. And I can take note that we will receive the 2 forthcoming expert reports, and we will receive them by 8 October at least. It can be taken note that within the interview of some witnesses, we found some references about some annexes used by the witness during their statements. And we didn't receive some of those annexes, or we couldn't locate them in the disclosure received. Of course, we have a talk with the SPO about that. Sometimes the links between some documents are not always very clear, and we cannot always identify to which witness some documents relate. So I think we will have an issue with all this problem during our discussion, I can say. I'm sure we will succeed to have something very nice for everybody. Thank you very much.
Thank you, Mr. Gillissen. Mr. Prosecutor, can you reply to the problems identified by the defense, please?
Yes, thank you, Your Honor. First off, I want to start by saying we continue to have what we view as a productive working relationship with defense counsel. We had a number of inter partes communications and an in-person meeting last week that's helped us to try to identify issues and try to resolve them wherever possible before bringing them to the court. In that spirit, the defense provided us yesterday with a series of issues they'd identified in connection with the disclosure materials provided to date. That included identifying a number of items for which they sought translations and a number of items for which they sought additional clarification on whether there were associated exhibits or annexes associated with transcripts that have already been produced. We're currently in the process of reviewing the information they've provided to us. We received it yesterday afternoon. We note that some of the materials they've identified for which they're seeking translations are materials that are not prior witness statements, but they're other types of documents. We expect to continue our inter partes discussions with them to try to resolve these issues, and if there are lingering issues, we'd bring them to the court.
Thank you, Mr. Prosecutor. Mr. Gillissen, please.
Yes, thank you very much, Mr. President. I think there is another point about this topic. It is the question of audio-video recording of some witnesses' statement and interviews. We are listing the reason why some, and I insist, some interviews are needed in the video format. I provide you some example. Missing interpretation, indiscernible part of the statement or interview, sometimes gesture of the witnesses in the description of certain elements, and the use of camera to show some exhibits. So it's limited, but we have the feeling it's really a need for us. Our main objective is, of course, to avoid some litigation about this disclosure of this particular audio-video linked. And I am sure, I repeat it, we will come to an agreement on this. Thank you.
Thank you, Mr. Gillissen. Do I take from the SPO and the defense that they will continue to work inter partes to solve these issues, and there is no request at this stage from the defense to for any specific order? Is that correct, Mr. Ayouni?
Good morning. Thank you, Your Honor. On this topic, of course, we in our discussions inter partes, we are aware of the case law of the tribunal about the audio-video recordings, and we've taken note on that, and we came into discussions with the SPO on a reasonable manner to engage in discussions where provided some justifications that are other than simply the verification of good transcriptions of audio videos. If we list in a non-exhaustive manner reasonable justifications to obtain the audio video, then they would accede to our requests. The ultimate aim, as Mr. Gillissen has said, is to avoid litigation on that. And I think we've agreed on a manner on which we can progress witness by witness. We've sent the first request yesterday to the SPO, which they acknowledged, and we are very confident that in our inter partes discussions we will come to the right solution, and we will be able to accede to those audio videos which are important for us and for our full understanding of the interviews of those witnesses without having to come before Your Honor. Thank you, Your Honor.
Thank you, Mr. Ayouni. Just one last question to the defense. Do you have any opposition to the expert reports, the forensic report, to be disclosed by 8 October as requested by the prosecution?
At this stage, we don't see any problem. As Your Honor know, we are busy with a very big number of other issues, so we can place that at the right moment when they are come. 8 October will come very soon, we believe, and we will have a lot to do, and we will be in the position to deal with it if it comes by that time. Thank you, Your Honor.
Thank you, Mr. Ayouni. Mr. Prosecutor, do you want to add anything on the 102.1b material?
Yes, just briefly, Your Honor. Thank you. Consistent with Your Honor's oral decision in Case 6, our position is that we're not required to produce audio-video recordings of witness interviews for which we've produced transcripts. That said, we've received the materials from the defense yesterday. We're currently reviewing it closely. We expect to continue our inter partes discussions with them in hopes to resolve this issue.
I welcome these inter partes discussion, and I hope you will find a common understanding soon. Before we move to the next category of evidentiary material, I will issue a first oral order. Having heard the parties, I will issue a first oral order, noting the SPO's request to be authorized to disclose expert reports relating to forensic matters pursuant to Rule 1021B of the rules, and having considered the reasons identified by the SPO, in particular that the reports haven't been finalized as it was initially planned, I hereby order the SPO to disclose the aforementioned expert reports by no later than 8 October 2021. This concludes my first oral order. And Mr. Prosecutor, should another extension of time be required in relation to the disclosure of any Rule 102.1b material in the future, I remind you to seek judicial authorization, as usual, by way of an official filing. Let us now move to the Rule 102.3 notice and evidentiary material. The SPO filed its Rule 102.3 notice on 3 September 2021. However, the SPO indicated in its written submissions that it foresees needing to supplement the Rule 102.3 notice in respect of two categories of material. First, certain material subject to Rule 107 restrictions, and this was already mentioned in the SPO filing of its notice on September 3rd. And second, material identified as a result of additional searches run by the SPO as part of a verification exercise to ensure that all relevant items had been captured. The SPO has identified approximately 500 items, which, if I may, is over a third more than the number of evidentiary materials initially listed in the notice. Before giving the floor to the SPO, I would like to recall that under our legal framework, the pretrial judge set disclosure deadlines after hearing the parties. The parties cannot, without judicial authorization, decide to supplement any category of evidentiary material after the deadlines. This practice would potentially not only delay the proceedings, but also prevent the opposite parties to conduct its trial preparation efficiently. So I would like to hear the SPO on the reasons why such a high number of evidentiary material has been identified only at this stage of the proceedings. I would also like the SPO to indicate if further searches are foreseen in its database to supplement again the Rule 102.3 notice. I inform the parties that I do not intend to issue multiple deadlines in the future about this category of evidentiary material. So I would like the SPO to indicate if this time it has really finalized its review and when it will be able to provide a final version of its Rule 102.3 notice. Mr. Prosecutor, you have the floor. Microphone, please.
Thank you, Your Honor. Your Honor, the SPO has tried to take an expansive view in identifying potentially relevant materials for inclusion in the Rule 102.3 list. As part of our efforts to identify all relevant materials, we ran a series of search terms against our databases. In rerunning checks to ensure that we'd captured all responsive materials, we realized that certain search terms had not been run in a particular database, resulting in the identification of these materials. Your Honor, I note that our internal checks, our routine internal checks, would have caught this issue before the final filing deadline, but for the fact that our internal database was down during the week beforehand, and so we were not able to check it and identify this issue in advance. We should have identified it in advance. We believe we now have identified all materials in our possession, and we have now listed them on the supplemental Rule 1023 notice. Of course, it is possible that in the course of reviewing our records, we will identify additional relevant materials, and we will then seek leave from the court to supplement, but we expect that would be a very isolated situation.
Mr. Prosecutor, you have filed now the supplemental notice. We cannot continue these proceedings with multiple updates like you do. It's very difficult for the opposite party to follow what you're doing. And again, this has to be done after leave from the court. You cannot supplement your notice like this every 2 or 3 weeks, every time you run a new check in your databases. I would like these proceedings to be organized. I set deadlines. I always set deadlines after hearing the parties, and especially the SPO. I, most of the time, do not put deadlines that are contrary to the way you're able to do things in all the cases. But let me be clear, you cannot decide to file any disclosure when you want, and especially when it's after the deadlines. If any party was doing that, the proceedings would be chaos. And they would last probably 2 or 3 times what would be needed, because the other parties would constantly ask for more time because there would be new disclosures. So I take from what you've been saying that you had an issue with the database. I perfectly understand that, and that's not an issue. But what has to be clear is that you have to request leave from the bench before you file this new disclosure. So now I hear that you think that most of the relevant items have been included in the list, but I also hear that you might have new evidentiary material in the future. If it is the case, then you have to seek leave from the court and you have to explain why these materials haven't been put on the list.
Thank you, Your Honor. That is fully understood.
Thank you, Mr. Prosecutor. Now I turn to the defense, please.
Thank you, Mr. President. About the evidence in the possession of the SPO that we request to access because they are relevant to our preparation, we received the famous notice on the date you point before. The party has agreed to have a common Excel table to work on, and we will use it to make our indication under and pursuant the Rule 1023. It's more comfortable for everybody. Of course, I take note that there is a lot of new intents. It's really an additional lot, very important one. I don't want to say just now we could be obliged to ask to some more time. It's too soon. It depends on what we will receive. And I can just say now that if we are able to make our indication sooner, it will be done. But of course, we have to discuss with Mr. Shala about all the things we will receive. So it's a little bit soon to take possession.
Thank you, Mr. Gillissen. Just one question for the transcript, because I think you mentioned there is a lot of new, I think you wanted to say items, and it has been transcribed that interns, and I also heard interns. So just to correct and to make sure that we've understood correctly, I think you meant items, not a lot of new interns.
That's sure, and I'm sorry, sometimes my accent of English is a dreadful one. I know it, but I try to improve it. Thank you.
And the bench appreciates that. Let me turn to Mr. Ayuni.
Yes, Your Honor, if you allow me, just to add some details on the notice itself, maybe explain what Mr. Gillissen was referring to. We kind of agreed with the SPO on a sort of a new protocol where we will share between us an Excel sheet of the table containing the documents listed by the SPO. We suggested that to the SPO in order to streamline our discussions, where we would use a common support, that is an Excel table, where we can make initial indications and they can make initial comments for us in order, again, to avoid any litigations and reduce to the bare minimum any disputes on the materiality. We believe that will be more effective and a better use of the time frame we have to resolve the Rule 102.3 notice. Obviously, we regret the additional items that will be coming. We don't know the impact of them, and we will be very attentive to whether some of them will fall under other rules like 102.1a or 103 particularly. So we will be attentive to that, but our first indications that in the meantime we will probably come to the SPO with requests for additional information about the descriptions that are contained in the notice. As Your Honor know, being in receipt of the notice in an annex, some of the descriptions that we have in the information are only contained in the titles and description of the documents. Some of them are not helpful enough for us to assess in an effective way whether it is relevant or relevant to a topic that is material to us. And we will continue using the support we agreed upon with the SPO to make all the initial discussions on those topics, request extra information, and make initial indications. As Mr. Gillissen said, if we are in a position to make indications in batches or in stages, we will do that for a better and more effective use of the time, and not to encumber Your Honors also with the filings if any disputes shall arise, and we will try to reduce them to where we agree to disagree, as we say. So that's what we had to say on the notice. Obviously, if the additional items are of a certain impact, we will come to you with a reasonable request, bearing in mind that the process we are trying to put in place will help us ultimately to come to you only when there is an agreed dispute on materiality. Thank you, Your Honor.
Thank you very much, Mr. Ayuni, and thank you very much to both parties for setting such working methods. I think it's in the interest of all the parties to be able to have this fluid communication. Mr. Prosecutor, before we move to the next category of material, would you like to add anything, especially on the defense submissions?
Your Honor, I think this is the first we've heard about the descriptions issue, and we look forward to continuing our inter partes discussion on this issue as we are with the other issues we've discussed. Thank you.
Thank you, Mr. Prosecutor. Let us now move to the Rule 103 material, which is exculpatory material. In its written submissions, the SPO indicated that it had disclosed 2 batches of Rule 103 material to date, and that review of potentially exculpatory materials is still ongoing. I would like to know whether there remains exculpatory evidence in the SPO's custody, control, or actual knowledge that must be disclosed to the defense, pursuant to Rule 103, and whether any request for protective measures for such material is imminent. Mr. Prosecutor.
The SPO has disclosed 2 batches to date, and review for potentially exculpatory material is ongoing. The SPO recognizes its ongoing obligation to disclose Rule 103 material, and it will continue to search for and disclose such material as it identifies it. We suspect that there is additional Rule 103 material in our possession. We are continuing to actively search for it, and will produce it on a rolling basis as we identify it. We don't have motions for protective measures imminent, but we would not be surprised if there are some that are identified given the nature of the materials in our collection.
Thank you, Mr. Prosecutor. Mr. Gillissen or Mr. Ayuni, please.
Thank you, Mr. President. Indeed, I can confirm that we received 2 badges of Rule 103. We are waiting to receive the rest of this material. I just can say the sooner the better. Thank you very much.
I think it's going to be the motto of today's hearing, so sooner the better. Thank you very much. Mr. Prosecutor, do you want to add anything on this?
No, thank you, Your Honor.
Finally, let us now move to the Rule 107 material. In its written submissions, the SPO indicated that apart from the Rule 102.3 material discussed earlier, no other Rule 107 material of relevance to the case has been identified. I would like to know whether the parties face any difficulties related to the disclosure process with respect to this category of evidentiary material. Mr. Prosecutor.
Thank you, Your Honor. That is correct that there is no other Rule 107 material other than the material we've discussed in the Rule 102.3 context. With respect to that material, I would note that the total number is now down to less than 30 documents that are still subject to Rule 107 restrictions or potential Rule 107 restrictions. And I would note, for Your Honor, just for context, that the majority of those documents relate to the issue of armed conflict as opposed to other issues in the case. We're continuing to work with providers to try to resolve these issues as soon as we can.
The sooner, the better. Mr. Gillissen, please.
Mr. President, I cannot repeat the same. So, very embarrassed. But it's exactly the situation. Thank you very much.
Thank you, Mr. Gillissen. Does any of the parties have anything to say on the disclosure process? No? Yes? No? Okay. So let us now move to the issue of translations of filings and evidentiary material. In its submission, the defense indicated that it has made a request for prioritizing the translation of specific material, which is being dealt with by the prosecution. I would therefore like to hear the parties on any further difficulties regarding translation. And let me start with the defense. Mr. Ayuni.
Thank you, Your Honor. As we previously said, we have sent a correspondence to the SPO where we identified in an order of priority the number of translations that we feel are missing, either in Albanian or in English or both of them. This is something we agreed upon, and we are listing it in a table. We are going to compare them and update them as we receive disclosures and keep contact. Some of the translations issues we face internally is for some categories of documents emanating from specific entities. For example, documents in different languages are present in different ERNs, and not what we are used to have in the same ERN with a code given the specific language. And so for that we seek assistance every time we cannot locate those documents because we have the doubt whether we have it or not, and we don't hesitate to list it in the table to the SPO because they probably are more aware of where it is present. And so we are hopeful to really dissolve all problems or issues regarding translations through this process. But we don't see any other concerns at this stance right now. Thank you.
Thank you, Mr. Ayuni. Let me turn to the prosecution.
Thank you, Your Honor. Very briefly, I confirm we're in receipt of the list of translation issues identified by the defense yesterday. We look forward to continuing our discussions about those issues in the hopes of resolving them wherever possible. Thank you.
Thank you, Mr. Prosecutor. I take note that you will continue to work inter partes on this, and as usual for the translations, the sooner the better. I like your suggestion of today, Mr. Gillissen. I think I will make it one of my key sentence for future hearings, especially when I will turn on the right side of this on my right side of this courtroom. Let us now move to the third item on our agenda, which is the status of the SPO's investigations and next steps. In its submissions, the SPO confirmed that it seeks an extension of time until 28 January 2022 for the filing of its pretrial brief, alleging the complexities of the case and the likelihood of overlapping deadlines in other cases. I recall that during the second status conference, the SPO confirmed that it would be able to file its pretrial brief by no later than Friday, 19 November 2021. Mr. Prosecutor, you filed an indictment in this case more than 18 months ago, and you are now asking to delay your pretrial brief to practically 2 years after the indictment was filed before me. More than 23 months, to be perfectly accurate. Do you really need that much time to prepare your pretrial brief? Because I don't see a clear link between the disclosure of the Rule 1023 material, which is the material you are not intending to use at trial, and the finalization of your pretrial brief, which will refer to the material you intend to use at trial. You also indicated in your written submissions that you wanted to expand the period between the filing of the pretrial brief and the filing of the Rule 109C chart. I would like also you to please indicate why the preparation of the chart cannot be prepared before the filing of your pretrial brief. You have the floor.
Thank you, Your Honor. Your Honor, we continue to believe that the requested period for the filing of the pretrial brief until the 28th of January is necessary to fully address the legal and evidentiary issues involved. It's largely a bandwidth issue. The resources required to respond to these Rule 1023 issues we're having with the defense are substantial, and we continue to think that it's appropriate to devote sufficient workload to each of these streams, and that's difficult to do simultaneously. We will, of course, meet whatever deadline the court sets, but we continue to believe that's necessary. We've tried to preserve the same distance, taking into account the judicial recess between the conclusion of the Rule 1023 period and the filing of the pretrial brief. But again, we will meet whatever deadline Your Honor sets, but we continue to believe this is necessary to fully address the issues involved. With respect to the Rule 109C chart, we've learned from experience in other cases that it's impossible to compile the information in the 109C chart until the pretrial brief is completed, and that's largely because the substance that's required under 109 and under 95.4 are fairly similar. It requires the prosecution to set out and categorize and analyze the evidence it intends to use, and so it's difficult to do one until the other is completed. Thank you, Your Honor.
Thank you, Mr. Prosecutor. Let me turn to the defense. Mr. Gillissen, on the timeline of the SPO pretrial brief.
Yes, of course, Mr. President. I'm obliged to say that to file a pretrial brief more than 23 months after the indictment, it's a very long time. That's sure. So I want to stress on this problem. I understand perfectly well the difficulties, but it's a very long time for Mr. Shala, who is, of course, indicted, but in jail too. So I think Mr. Hawini will complete the idea. Thank you very much.
Thank you, Mr. Gillissen. Mr. Ayuni.
Thank you, Your Honor. Your Honor, our position is extensions of delays that are reasonable based on what is going on the procedure. We would not press too much at this stage because we are using this time very effectively and densely in getting prepared on our side. We note, of course, and we thank you for the indications and putting this deadline into context. We will not make further submissions on this issue, but I will probably repeat the same word of the day, that is, the sooner the better. We take note of the judicial recess and the reality of the working days towards the calendar days when we go through a recess, either summer or winter recess. But as Mr. Gillissen said, those are days that Mr. Shala is spending in jail. And so the less before he starts his trial would be the better, of course. We indicated that we don't oppose any reasonable delay or postponement of deadlines when they are reasonable and justified. But we will leave it at that at this stage because we have many things that we are dealing with at the same time, and we are pretty confident to advance in the meantime to be able to address the pretrial brief and the contents of it. It is important for us to receive the most complete and clear pretrial brief and chart as possible. So that's also in the balance. But we believe it could be done in a deadline that is shorter than that. The SPO indicated he will meet the deadline Your Honor will set, so we will wait for that. Regarding the chart, we understand technically the difficulty of putting together the references and the need to do it properly. We have faced, as we mentioned yesterday, some issues where we could locate or establish the links between documents, place the documents in their context, and the links between documents and witnesses. We believe the chart will be extremely important for us. We are ready to accept an extra time for the benefit of the quality of the chart. And again, as we indicated in the first status conference, we believe the same margin should be applied if the defense should file a pretrial brief of its own. So those are our submissions on the point. Thank you, Your Honor.
Thank you, Mr. Ayoni. But to be clear, you do not oppose the request of the SPO to postpone the date of the filing of its pretrial brief. You take note that you would rather have it sooner than later, but you do not formally oppose the request, correct?
Exactly, Your Honor. It's not a full opposition. It's not a full acquiescence, of course, although we have indicated that in our filing. The word of the day, the sooner the better. We just put in context that we are using this time to advance on our own. We're not wasting the time, and Mr. Shala himself is aware of that. But of course, this is additional notice and additional material to the defense that can only make our work more effective. We will face the same issues of deadlines. We don't want to be unreasonable because we will have to provide the same kind of information at some point. So these are the positions, and we leave it in your hands to set the right deadline on that. But no later than what the SPO asked for.
That I would not allow. Thank you, Mr. Ayoni. Mr. Prosecutor, I think the defense has a very constructive approach, and if I may suggest a deal, it doesn't oppose to the postponement of the deadline as long as disclosure is done efficiently and in a cooperative manner, and as long as the pretrial brief is also done in a detailed fashion so that they can prepare the case as efficiently as they can. Do you have any input you want to add after the defense?
No, Your Honor, that's understood. Nothing further from us.
Thank you, Mr. Prosecutor. I will issue another oral order. Having heard the parties, I will issue a second oral order, noting the SPO's request to vary the time limits for its pretrial brief and its Rule 109C chart, and having considered the reasons identified by the SPO, in particular, the need to sequence the disclosure process and the filing of the pretrial brief and the Rule 109C chart, as well as the fact that the defense does not object to the requested variations on the basis that it prefers to favor the quality of disclosure, I hereby order the SPO to submit its pretrial brief by no later than 28 January 2022 and to submit its Rule 109C chart by no later than 11 February 2022. this concludes my second oral order. For the next point on the agenda, I would like to turn to the defense first. I note from the defense written submissions its intention to carry out investigations for the purpose of the presentation of its case. The defense also flagged serious difficulties it has encountered with conducting investigations in the field. I invite the defense to elaborate on these difficulties. Mr. Gillissen, you also indicated in your written submissions at this stage of the proceedings that you are not able to confirm at present whether you will make any request concerning unique investigative opportunities, that you are not able to indicate at present whether you will provide notice of an alibi and or any other ground excluding criminal responsibility, and that you are not able at this stage to confirm whether you will be filing your pretrial brief and related material and when you will be in a position to do so. Could you specify when you think you will be able to give a timeline on these procedural steps? And do you need the SPO to file its pretrial brief before you are able to respond to any of these questions? Mr. Gillissen, please.
Thank you very much, Your Honor. We were aware that things would not be easy in the area of the investigations on the ground. I have to confess we didn't know how much more difficult they would be. We have to face some difficulties, but I can say just now things are improving. We found some investigators and the contact with them are really a failure. So we lost a lot of time, really. But really things are improving because we have a new contact and it seemed to be the good one. I can explain the kind of difficulties we have to face, but I prefer not to explain it in a public hearing because it's a little bit delicate, but that's really big problems, I can say. So the best it could be to wait for the prosecutor brief because we will be aware, fully aware about all of the elements, and it could be more interesting for everybody. So when we will be able to provide you some information, we will come back, of course, to you, and I can say the sooner the better, Mr. President.
Thank you, Mr. Gillissen. If you wish to address the court either in private session or in an ex parte filing, feel free to request it so we can discuss of any problems that you face in your investigations. So I take it that you are now trying to resolve them, but in the following weeks, feel free to come back to me on these issues because we can try to solve the problems and especially the practical problems you may face on the field. Mr. Prosecutor, do you have anything to add to the defense here?
No, thank you, Your Honor. Not at this time.
Thank you, Mr. Prosecutor. Let us now move to the next item in our agenda today, which is the points of agreement on matters of law and fact. I would like the parties to indicate if they anticipate being able to identify a list of issues subject to dispute and one with issues not subject to dispute. In this regard, I note that the parties have entered into preliminary discussions regarding the possibility of submitting points of agreements on law or facts pursuant to Rule 95 and 156. I would like the parties to indicate when they will be able to reach an agreement on these issues. Mr. Prosecutor.
Your Honor, we don't have a precise time frame at this time. We do expect that we would reach agreement on as many issues as we're able to by the time of the filing of the pretrial brief, as contemplated in Rule 95.
Thank you, Mr. Prosecutor. Let me turn to the defense. Mr. Gillissen.
Yes, Mr. President, we start the discussion, preliminary discussion with the SPO. We are waiting for the proposal and propositions of the SPO, and when we will receive it, we have to discuss it, of course, with Mr. Shala. And I suppose things could be better when we receive it. It's impossible now to make more statement. I think so. Thank you.
Could you elaborate on the timing, Mr. Gillissen? Do you think you will be able to reach an agreement after the SPO has filed its pretrial brief, or do you think this could be done before? Mr. Ayuni.
Thank you, Your Honor. I think the SPO mentioned that he is optimistic that we would reach as many agreements on points of law and fact by that time, by the time of filing his pretrial brief. Of course, the starting act comes from the SPO. He will make the proposals to us as to points of agreement of, he seeks the agreement of Mr. Shala on points of law or fact. And Your Honor understand perfectly that the ultimate decision on these issues will be Mr. Shala's decision. So we will wait for those points. We will endeavor to promptly and efficiently submit them to Mr. Shala and inform him about the consequences and context of each point and possible impacts on the conduct of the proceedings. And as soon as we have his decisions on those points, then we will communicate them to the SPO and probably report to Your Honor on them. If I addressed your point, Your Honor? Yes, thank you.
Absolutely. Thank you, Mr. Ayuni. Mr. Prosecutor, do you want to add anything?
No, thank you, Your Honor.
Microphone.
Sorry. Thank you, Mr. Prosecutor. And let us move to the next topic on our agenda, which is detention. I would like the registry to provide an update on the detention regime, notably whether the meetings between counsel and the accused in the detention facilities have now returned to the pre-pandemic regime, and whether the registry has resumed family visits of immediate family members. Mr. Roche, please.
Thank you very much, Your Honour. As you may recall, on the 9th of September, the registry filed submissions relating to the conditions on detention. That was filing number 73. So I won't repeat all of the content, but in summary, face-to-face meetings with counsel have been possible under kind of pre-pandemic conditions since the 1st of July and have been occurring, as I understand, on a relatively frequent basis without any issues raised to the detention management unit. As regards in-person visits, visits with close family members have been possible since the 15th of July, and I understand one visit has occurred. As of the 6th of September, other personal visits are also permissible, and further visits, I understand, are scheduled for Mr. Shala either in the course of this month or early next month. So thank you. If you have any further questions, I will, of course, answer them. Thank you.
Thank you, Mr. Roche. Let me turn to the defense. Do you want to flag any issue related to detention? Mr. Gillissen.
Thank you very much, Mr. President. It's always a delicate issue, of course. And I would like to first to thank you, Registry, for the efforts and the dedication they have made today. We are constantly monitoring the situation with Mr. Shala. He is very helpful for us because he is able to provide us some information, and we are particularly receptive in this issue he raised, and we know he had to face some real problems. But we are in regular contacts with the registrar official, including Mrs. Registrar, and really I want to thank them for their availability, because really it was very helpful for us, and particularly for Mr. Shala, of course. So I'm sure that the issue will be found, and a solution will be found, and conditions will continue to improve with the goodwill of all the parties involved. So we are waiting for the future, but I have the feeling things are better now. We have faced some incidents, but it's not now, in my opinion, time to talk about it in a public hearing. Thank you.
Thank you, Mr. Jlissen. Mr. Roche, do you want to add anything?
Thank you, Your Honour. Just to say that the face-to-face or one-on-one dialogue between the registry and the defence, I think, has been mutually extremely beneficial to allow for the resolution of issues at the quickest and most comprehensive manner. Thank you.
Thank you, Mr. Roche. At this point, I would like to ask the parties if they have other issues they would like to raise. Mr. Prosecutor.
Thank you, Your Honor. Nothing further from the prosecution at this time.
Thank you, Mr. Prosecutor. Mr. Jlissen.
Yes, Mr. President, I would like to introduce to you an oral request. I'm really sorry because I know perfectly well I'm very late to make it and to introduce it. With your leave and under your control, that's sure, I take my responsibility to explain to you the problem we are meeting. So, as you know, we are just now in the process of finalizing our written reply to the SPO response to our preliminary motions. And despite our best effort, we realize it will be short with the word limit. And the issue concerns the two kinds of preliminary motion we have put on the table. And we would like to grant us an extension of 2,000 words for all the replies in the both preliminary motion response. Really, you have to be aware that we are sorry to introduce this request so lately, and it is really to try to succeed in the quality and the nature and the quality of our arguments. It's the interest of the quality of the debate itself. So that's why we dare to introduce this request to you. And I'm sure now we believe that 2,000 more words will allow us to properly address the SPO submission in an effective way, which will assist you, Mr. President. Thank you very much.
Thank you, Mr. Jlissen. Do I take from your request that you would like to be able to reply to each response of the SPO with an extension of word limit? Or is it like one consolidated reply? And whether it's one or two, would 5,000 words in total be sufficient for your reply?
Sorry, Your Honor. You might have understood that we work as a binôme, as we say, so we will complete our request for Mr. Jlissen. We are intending to file 2 replies on each of the challenges, the jurisdiction challenge and the indictment challenge. We're in constant contact with our drafter, and despite our best efforts, we believe we will not be comprehensive and address fully the submissions of the SPO if we don't get this extension of word limits. If we are allowed 5,000 words total per reply, that would be great. If we get a little bit extra for the jurisdiction, that will be even better. Your Honor, understand that the jurisdiction motion and reply had more word limits in total. We leave it at your hands. The extension will be beneficial for the quality and the substance that we put in our replies. Thank you, Your Honor.
So to be clear, you would like an extension for each reply. And second, you would like 5,000 words, and if possible, even more for the jurisdiction. Is that correct? And if so, what would you need? 6,000 words?
It would be highly appreciated, Your Honor. We're working on eggs, so we know we are late with our request, so we will appreciate any extension. We've been trying to condense and put it, we are not succeeding. We understand it's substantial extension of word limits we are trying to put before you, but we believe it's necessary for this important issue. We thank you for your indulgence, Your Honor.
Thank you. If I may, the sooner is always the better, but the longer is not always the better for the product. Being concise is also quality. Mr. Prosecutor, what do you have to respond to the defense request?
Your Honor, no objection to the defense request from the prosecution. We'll defer to Your Honor about the appropriate extension.
Thank you very much. Do you want to add anything, Mr. Gillissen, Mr. Yeni? No?
No, thank you very much, Mr. President.
Then I will rule on your request from the bench, given the timeline of your reply. After having heard the request of the defense, I will issue a third oral order. I consider that good cause constituting exceptional circumstances to justify a variation of word limit for the replies to the SPO response to the preliminary motions to challenge the jurisdiction of the KSC and the form of the indictment have been established. In particular, I take note of the defense need to fully argue the complex issues arising from both preliminary motion responses. I further note that on September 3rd, 2021, I granted a similar request filed by the SPO and that the SPO does not oppose this request. Accordingly, I authorize the defense to file replies to the SPO responses to the preliminary motions of the defense, not exceeding 6,000 words each. This concludes my third oral order. I would now like to ask the parties for their views on the next status conference, which is currently pre-scheduled for 15 November 2021. Mr. Prosecutor.
Thank you, Your Honor. We'll be available at the court's convenience, and we are available on that date.
Thank you, Mr. Prosecutor. Mr. Gillissen, please.
Thank you. It's exactly the same, Mr. President. It's perfect. Thank you.
Thank you, Mr. Gillissen. You will receive a scaling order that will include the agenda before the status conference. I also invite the parties to make written submissions if they would like to raise any specific issues during the next status conference. And I mention this especially for the defense. If you face any difficulties for your investigations, I would appreciate that you file written submissions, ex parte if needed, so that we can have a specific segment of the next status conference dedicated to this topic. Do the parties have anything else to add for today, Mr. Prosecutor?
Nothing from the prosecution, Your Honor. Thank you.
Thank you, Mr. Prosecutor. Now I turn to the defense, please.
Nothing to add, Mr. President. Thank you very much.
Thank you. This concludes today's hearing. I thank the parties and the registry for their attendance. And as usual, I'd like to thank the interpreters, stenographer, audiovisual technician, IT technician, and security personnel for their assistance. The hearing is adjourned.
All rise.